Good morning everyone. Welcome to Byjus Exam Prep IAS. Now we are going to discuss the important news from 8th February 2024, and as you can see the topics that we have chosen to cover today. The first one is mixed reactions in Northeast to centers move to fence India and the Myanmar border. Now if you all remember, this is a topic that we have covered a few times in the last few days, and not a lot to look into this today, and that's why I will show you some different dimensions about this topic in the present class. Point number 2 is over 20,000 FCRA licenses cancelled, and most from Tamil Nadu. Now this is a data heavy topic, and we don't have to look into all the data, but we have to understand few issues regarding the FCRA licenses. The third one, another editorial that has come, downloading child pornography is an offence. Now we will see here a recent judgment, and this editorial is saying that that judgment is not correct. They are writing against this judgment given by High Court of Madras or Chennai. So they are against this. The fourth one is equity concerns in banning fossil fuel extraction. Now a very, very important topic from the perspective of climate change. And if you all see the COPs that have happened in the recent past, like Dubai, etc., similarly Kyoto Protocol and all these, we shall be talking about them under this topic. Fifth one, can't treat the scheduled castes as homogenous group, observes CJI-led bench. A 7-membered bench led by our Chief Justice of India is basically rejecting the I would say judgment given almost 2 decades earlier in a very famous landmark case, and they are saying we should not treat the scheduled castes as homogeneous group. So we shall be looking at these 5 topics. The first one is very small. The rest of the 4 would be slightly lengthy. Moving ahead of this, we also have some topics for Prelim Bytes. And in the first topic, in breakthrough neural network explains how it found new antibiotic. Number 2, Tripura board allows Kokborok in Roman script in examinations. And number 3, 390-year-old lamppost in Nalgonda unravels trade links of Telangana. So you can see in prelims, one topic we have taken from science. This can be used under the art and culture, language topic, and this is basically your medieval history. And in this lecture you will see I will try to cover as many aspects, like there would be foreign travelers, some mention about some rulers of that era. Similarly, I'll also show you geography through map concepts through this particular topic. So all those things, for example, right now, you can see Nalgonda is in Telangana, it's mentioned. But if somebody did not know about that, so how would you know and how you should remember these things? That's very, very important. Without wasting the time, let's begin. We are already slightly delayed today. I'm very sorry for some technical issues. We have started a bit late, but let's begin with this. The first topic, mixed reactions in Northeast to centers move to fence India-Myanmar border. Now again, those who have attended the previous few days, they would know that we have clearly said that, for example, states like Mizoram, they are not happy with this fencing. On the other hand, states like Manipur, it is they who have said that this fencing should definitely happen. So similarly, in this you can see Chief Ministers of Arunachal Pradesh, Assam and Manipur have welcomed this decision. And Mizoram and Nagaland counterparts, they are against this. So, please understand. Number 1, what is this announcement? I said earlier also, again I am repeating, Honorable Home Minister, Mr. Amit Shah, recently made an announcement that the center is going to fence India-Myanmar border. Now you all can understand the concerns of the Home Ministry is that if we do the fencing, we can do better surveillance and we will be able to do better patrolling. Now, with regards to this, there is almost 1,643,000 kilometers of border. the 5 states, they are having different views. As I said, Mizoram and Nagaland are on one side, and on the other side, let me change the pen color, you have Arunachal Pradesh, Assam and Manipur. Now everyone, if I ask you something, let's start with something of prelims. I'm asking you the first question. These 5 states are mentioned. Are all these states sharing a border with Myanmar? If tomorrow the prelims question comes, which of the following states do not or do share the border with Assam, with Manipur, I'm really sorry, with Myanmar. So remember, I mentioned all the 3 names because you should not get any hint that did I say the correct answer. So let's say if there is a question, which of the following states do not share the border with Myanmar? The answer can be all 5 share. No, some of these states do not share. Please comment in the chat box. Hopefully you would have commented by now. So let me tell you, these 4 states, they share the border, and Assam does not share the border with Myanmar. So that's your first question. Similarly, if I ask you, you all know, apart from these 5, 2 more states. You have Meghalaya and you have Tripura in this. Let's say if I add those 2 states also, I'm asking you the question again. These 2, do they share the border with Myanmar or not? What would be your answer now? Will you add any other state to Assam, or will you not add these 2? So let me tell you, even Meghalaya as well as Tripura do not share border with Myanmar. So in Northeast, the 4 states which share border with Myanmar, they are Mizoram 1, Nagaland 2, Manipur 3, Arunachal Pradesh 4. And you can see 2 of them favor fencing, 2 of them do not favor fencing. So that's how it is divided right now. So why is Assam also speaking on this? Please remember, Assam's logic is that if we do the fencing, the terrorists or the insurgents who are using the Myanmar's land against their operations or for their operations against India, they will not be able to do this. Now, in this article, there is one more point, okay? There is one more point about FMR. We have already studied free movement regime. If you all remember, we studied it earlier when we were discussing India-Myanmar relations a few days back, that this is an agreement under which the people of both the sides can travel up to the 16 kilometer in each other's territory without any visa. So let us conclude this topic with the whole idea. Why are these saying it should be done? Because they are saying this way we will be able to stop the insurgents from coming on our side. Why is Mizoram and Nagaland saying it should not be done? That is, fencing should not be done, because they are saying same people are on both the sides and they have a right to live together without any barriers. So they are saying the people on this side of the border and the people of this side of the border, they both have similar ethnicities, so they should not be divided. Not only these, let me tell you, even the non-state actors, like in Naga Talks, you would have heard a lot of time about ISAC Muya groups. They also are opposing, saying that, see, this should not be done. Similarly, there is, in Myanmar based, there is a group called Khaplang Yung Ong group faction, or you can say, they are also opposing this plan. So if you look at this, this is more appearing to be from the perspective of prelims, And I would request you to please go back and look at India-Myanmar relations. 2-3 days back only we have covered in our articles in a very, very broad manner. So in a very nutshell, we have covered this. Let us move ahead. The second topic, as you all can see, is the page number 8 environment topic, that is equity concerns in banning fossil fuel extraction. Now the author is Anwar Sadat or Sadat. He is a senior assistant professor in international law at Indian Society of International Law, New Delhi. So he has written this particular article. Now if you look at the crux of this particular article that I have written over here, he is saying that the countries which are heavily dependent on revenues and employment when it comes to fossil fuel sector, they are going to have some serious difficulties in the transition. For example, let's say you take example of India only. Now India, if tomorrow they ask us that stop using these fossil fuels, okay. For example, a person like me who is sitting right now in Bangalore and fossil fuels uses is stopped, maybe I would suffer in the sense that electricity will become costlier, maybe. But think about a person who is from Jharia, who is involved in these coal mining, and tomorrow if all these coal minings or coal mines are closed down, don't you think those people, their employment will be affected? Think about the states like Jharkhand, who would be earning so much of revenues. So invariably, don't you think that taking one stand and closing down all these fossil fuel, I would say mines, etc., is not that easy. So the author is raising all these concerns. Of course, he's also saying that, there are international legal systems where any country has the right to use its natural resources that are in their territory. For example, again, think about a country like, let's say, Saudi Arabia. Now, we all know their economy is heavily dependent on the petroleum, the petro fuels that generate the revenue. Although they are doing a lot of diversification now, they are opening their, I would say, borders, they are inviting people, they are inviting different types of business. In fact, they are doing a lot of tourism thing. I remember recently they have come with their Saudi tourism initiatives, and I think most probably in IPL and also they are getting attached with IPL. They are trying to show Saudi Arabia as a tourist destination. They are doing all that. But you cannot expect them that in a day they will stop their reliance on the fossil fuels. That's not going to happen. At the same time, they also say these laws, this writer, the author is saying, these laws also are accompanied with a caveat that something that you do in your jurisdiction should not be harming another state if it is a transboundary item. So these are the crux of this particular news item or this article. Now, if you see here, the fact that the author is saying that there is a idea that we should phase out fossil fuels subsidy, plus we should ban the extraction of fossil fuel itself. Now, this is basically, the author's point is that this is a demand being made continuously by climate change activists, and this is leading to a lot of litigations in various parts of the world. Climate change activists, they are not entirely happy or they are not entirely convinced with the response being given by the governments, and that is why they are calling for this. In nutshell, if I say, there is a momentum, according to the author, in favor of a fossil fuel NPT. I hope you all know the full form of NPT, Non-Proliferation Treaty. So there is a growing demand that there should be complete ban on the use of these fossil fuels, in which of course coal is a very, very big item. And that's why they are saying even coal should be eliminated. There should be a coal elimination treaty by 2030. So under this they are saying ban the mining as well as ban the burning of coal. Now all of you can understand, I said at the very beginning, let's say for a second hypothetically think in 2030, by 2030 we are banning coal, we are banning the use of coal. Now climate activists, they are thinking about this from one angle of climate. Of course we respect that, but at the same time think about the lakhs and millions of people who are dependent on this, on coal for their survival. Because miners, think about that. Are you going to give them some another job? Have you ever thought about that? You are not talking about this. Why are the activists talking about this? Activists are saying that the fossil fuel producing countries, they are producing a lot of coal. In fact, they would be producing much more coal than now. And if this happens, the talks that have happened and that were done in Paris Agreement 2015, where we had said that we will keep the climate change or the temperature not go above 1.5 degrees Celsius to the pre-industrial level, that would not be obeyed. So the climate change activists are saying that, see, we are not on the right track. The fossil fuel will never allow our, this global warming to come down. So as I said at the very beginning, that previously a lot of these conferences have happened. If you talk about UNFCCC, that is United Nations Framework Convention on Climate Change. Now they organized their COP26 at Glasgow. This was done in 2021, and there they had said that they would be phasing down coal power and even phase out any inefficient fossil fuel subsidies. So they said that we are going to do this. Now, for example, if you are talking about any inefficient fossil fuel, let me give you one example: kerosene. India, I'll show you later that the fact that we give a lot of subsidy for kerosene people, people who use kerosene, because a lot of people in the lower strata, they use kerosene for their daily use, and India is giving a lot of subsidy for kerosene, and kerosene is thought to be an inefficient fossil fuel. So even those subsidies are coming in the eyes of the, I would say, the developed nations. So they are protesting against this also. Now, apart from UNFCCC, UNFCCC, you can also talk about COP28, which happened in 2023, that is Dubai. They have decided that they will try to achieve net zero emissions by 2050. And based on all these discussions, some of you might be knowing, those who have studied your environment and ecology, there were some decisions taken like common but differentiated responsibilities and respective capabilities. Along with this, there was one more decision done: nationally determined contributions. So in order to stop the climate change, these were some of the most important decisions that were done. See, before this also there are many landmark decisions, judgments which you all study in your regular environment and ecology classes. Like if you talk about the Kyoto Protocol, I've already talked about the Paris Agreement, where they all talked about that how to reduce the greenhouse gases. Now, if you all see here, the name only says common but differentiated responsibilities and respective capabilities. For example, let's say US, and let's compare US with my favorite nations for the day, Maldives. Now, everybody knew that historically US would have contributed a lot to the climate change. Maldives would have never done. Similarly, let's take another example, let's say France, and compare it to another country of Africa, their colonial nation or the nation on which they were ruling, Algeria. Now, France is a developed country, Algeria is a developing country. How can you expect both these countries to have a similar target? So, based on the criteria of per capita emissions, India is a country of more than 140 crore people, and there might be another country which would have in population in lakhs. Similarly, the historic emissions which were done by a developed country, I'm sorry, eraser, just a second, developed country, and the financial plus technology resources that has to be deciding the targets for different countries. So in this article they have given example which I already said, and let me change the pen color. I have already told you, let's take example of Canada, US, UK. Now these countries are less dependent on fossil fuel because they have a more diversified economy, because they have some non-fossil fuel incomes also which can help them in their costs, plus they have a high per capita income. Therefore, if these countries were asked to move from fossil fuels to non-fossil fuels, it is easier for them for transition. Now in this article they say compare this to countries like Azerbaijan, Congo, Nigeria, Oman. These countries, they are heavily dependent on fossil fuels, because I told you, I gave example of, let's say, Saudi Arabia. So a lot of revenue that their governments earn, they come from these fossil fuels. So their economy is also less diversified. So the author is saying you cannot expect these countries to take a lead in this case. Now, in this article, the next point that the author is talking, what about the international laws? I already said international laws make it very, very clear that any country can use the natural resources that lie within their territory or within their area for their economic development. But then at the very beginning I said the crux of this article is there is a caveat to this. You cannot cause significant harm to another state. If a natural resource is transboundary in nature. So basically, let's say I'm using a lot of coal, it causes a lot of pollution. So maybe under the international laws, I cannot be using it because it is causing a significant harm to my neighborhood country. Now, in this, you can clearly see prevention of harm to another is a due diligence obligation. You have to be doing this. Take all the appropriate measures so that another state does not get affected. Now, this international law, in this article, they have mentioned about a pulp mills case. This case came in 2010 and given by International Court of Justice. So here they talked about that you should conduct a trans-boundary environmental impact assessment. Very, very important topic for your environment and ecology. So they are saying, and this EIA has to be done. It's a customary international law that should not be ignored. Last part of this article, as we said at the very beginning, what about India's situation? Are we getting impacted? Absolutely. I told you there are many districts in India, for example 159 districts, and the article talks about that 3.6 million people in these districts are directly or indirectly dependent on jobs which come from coal mining as well as power sector. So you can understand it's not that easy for us to phase out all these, I would say, your fossil fuels. At the same time, India's situation is also in one sense getting affected because we give a lot of subsidy on products like kerosene oil, and the Western countries, they are scrutinizing this. Western nations are questioning this, saying that our subsidy on kerosene oil is inconsistent with the article, sorry, 2.1, sorry, it should be 1. Article 2.1c of the Paris Agreement. Because I have already said to you that kerosene and the subsidies which are given to it, they are considered as inefficient subsidy. So what is our stand on this? We have made it very, very clear that, see, there is a differential time frame. We mention it very clearly at COP 26. The language that, we asked them was, rather than using the word phasing out, we'll be doing the phasing down of unabated coal. So definitely we'll be bringing down our use on this. So the author is clearly saying that, see, you will have to raise these issues. We'll have to form coalitions of like-minded, countries who should raise the hypocrisy, which is going on right now, because many advanced countries like Australia, Canada, US, they are on one hand talking about increasing their coal production. On the other hand, they expect the far less developed countries or developing nations to phase out their coal or these fossil fuel usage. So this is basically the topic which we just now dealt. The topic is equity concerns in banning fossil fuel extraction, something which you can use for your environment and ecology. Moving ahead to the third topic, you all can see 20,000, or rather I should say over 20,000 FCRA licenses cancelled, and they are mostly from Tamil Nadu. Again, if you see the crux of this, they are talking about that FCRA registrations of Delhi-based Center for Policy Research, World Vision India, were cancelled. 23, Home Ministry has recommended CBI investigation in Oxfam India for violating FCRA regulations or provisions. Similarly, CBI has conducted searches, registered case against news portal NewsClick for violating FCRA in December 23. So a lot of such news is coming. So here you have to understand the first thing, why it is in news. It is in news because recently CBI filed a case under FCRA. Let me tell you first of all, the full form of this is Foreign Contribution Regulation Act. So basically CBI has filed a case of violation of FCRA against the human rights activist, his name being Harsh Mandar, and his NGO, the Center for Equity Studies. Now, I'll tell you about FCRA. Before that, just one or two lines about Harsh Mandar. Started his career as an IAS officer, served in states like Chhattisgarh and all, and later took retirement in the early part of 2000s, and then started his career as a social activist, formed these NGOs and all that. In the last 20 years has been a part of many landmark, I would say, decisions. Some of them, for example, was a member of National Advisory Council of the UPA government, was Special Commissioner to the to the Supreme Court of India in the Right to Food campaign. So you can understand, he is a very prominent personality, and against him, this case has been right now filed by the government of India. The Home Ministry has asked CBI to file the case. Now, why is this case being filed? This case is, they are saying that the money has got diverted. Money has been diverted. The FCRA account, which is used to give salary, wages of the employees, some money has been diverted here. Now, the thing is, why we have chosen this article, and if you look at the tone and tenor of this article, clearly this article is saying that a lot of licenses have been cancelled. And I gave you the examples also of very, very prominent NGOs and international bodies whose licenses have been cancelled. So, I'm sorry. So in this, the article, and in the news also it has come, that in the last few years, FCRA has cancelled FCRA licenses of CPR, that is Center for Policy Research. Similarly, World Vision India. Similarly, case against Oxfam India. I said NewsClick. So many of big, known, reputed organizations, their, I would say, licenses have been cancelled in the last few years. Now, let me tell you, some people are saying not everything is correct in this. For example, in 2017, in a peer review which was done by UN Human Rights Council at Geneva, Indian government had to face some very, very tough questions from a lot of countries, mainly of Europe and US. In Europe, Germany and all, they raised questions on our actions, and they said that a lot of times the decisions taken by our government is arbitrary. That is, there is no valid grounds, or they are doing it according to their whims and fancies. Now, hopefully you all understand what is the violations, FCRA violations are or is used on whom all, and now we have to understand what exactly is this FCRA. Foreign Contribution Regulation Act was passed in 2010. The whole logic of this was that, look in the scope of all the acceptance, all the utilization of any foreign fund or any foreign contribution. If any money has come, why did we accept it? How are our bodies, the NGOs and all, they are utilizing it? Are these activities in any way detrimental to the national interest? All these are being considered under FCRA 2010. Now later, around 2020, Honorable Home Minister Mr. Amit Shah had passed an amendment to it. And amendments now were asking all the NGOs, office bearers, if you are a office bearer of any NGO, you should provide your Aadhaar numbers. it also gave powers to the government to do any summary inquiry so that any organization could be prevented from using the foreign funds. And because of all these, of late, as I again am repeating, many of the reputed institutes like even Amnesty International, the human rights watchdog, they announced in 2020 they are wrapping up their operations in India. Why are they wrapping up their operations in India? Because they said that the Narendra Modi led government, they are basically, or they have basically completely frozen their accounts. So everyone, the crux of this article is this, but then let me show you. They have also given some charts. As you all know, in editorial, this is one point where they give a lot of data, and in this data you all can see, if I use this, the chart one shows the year-wise cancellation of these licenses. So if you see here, clearly 2015, when more than 10,000 such licenses were cancelled, is a big number. Apart from that, 2017 is the second highest, but then there are many years, like if you see in the last 5 years, the number is 0, 3, 15, 4, 3. So a lot of cancellations have happened. Now, some years, big number of cancellations. Most of the years, very few cancellation. Now remember, some cancellations have happened because of violations. Some have happened because there were multiple registrations for the same organizations, and that's why they were cancelled. Now if you look at the chart number 2, chart number 2 says the state-wise number of active, expired and cancelled FCRA registrations. So you can see here, Tamil Nadu is highest when it comes to the organizations whose numbers have been cancelled. Clearly, they have a lot of cancellations. Of course, they have a lot even now active, almost more than 2,500 active licenses they have, which is highest amongst all the other states if you look at this number. So that's the other thing. Third, the table shows the breakup of organizations with the active FCRA license. Again, just now I said Tamil Nadu is at the highest. Last, very important, it shows how much every state has received the money, and this is financial year 2021-22. Clearly, Delhi is at the top. Even though the number is highest for Tamil Nadu, it is Delhi which has received almost 5,800 crores as FCRA, or the amount as FCRA. Then number 2 is Maharashtra with number 2 is your Karnataka with 3,141, Tamil Nadu with 2,507, and then Maharashtra. So my point is, don't go anywhere, just remember 2-3 things. This year, when the cancellations were more than 10,000, rest of the years it is very less. Do remember, Tamil Nadu has got the highest cancellations, but all the cancellations are not because of violations. Some of them are also because there is duplication. Third, you should remember, Tamil Nadu has still the highest number of FCRA licenses, and Delhi, followed by Karnataka, followed by Tamil Nadu, and followed by Maharashtra is the number of getting these amount of money as the FCRA, amounts. These 3-4 things, and apart from that, the examples that I gave you, this will make you write a very good answer on the actions of the government against these NGOs. Moving ahead, you have the next topic is downloading child pornography is an offence. R.K. Vij, an IPS officer, and let me tell you, this part is basically section 67B having 5 sub-clauses, and this article very much relies on the article or your subclause B. Apart from this, this article also talks about POCSO and the IT Act. Overall, let me tell you in a nutshell, in this article, the Honorable IPS officer, the former IPS officer, is disagreeing with a judgment given by Madras High Court. So let me tell you what has happened here, that Madras High Court, they have given a judgment. Now if you remember the judgment name, it is S. Harish versus Inspector of Police. What is the judgment? The judgment says, the Madras High Court is saying that downloading child pornography is not an offence under Section 67B of IT Act 2000. Now, all of you, please remember, very, very important, your blue pen. This IT Act was passed, as you all can see, in the year 2000, and this is the primary law in India that deals with any issue related to cyber crime and any issue related to electronic commerce. So please remember IT Act 2000. In internal security, you must be taught about this and you must have studied also. Now, everyone, judgment you can see. I said they are saying that downloading child pornography is not an offence under this act. Madras High Court is saying that the person merely downloaded it, watched it in his private. That is, he did not circulate it, he did not pass it on. And Madras High Court in this takes help of another judgment which was given by Kerala High Court. In that judgment, Kerala High Court said that watching porn in private is not an offence of IPC. So in this, a youth was found to be watching porn in 2016 on his mobile phone at a roadside. The police had arrested him. Later, the Kerala High Court said that, see, just merely the fact that he was, watching this porn, he cannot be arrested because he was watching it in private, and that's not an offence. So the Madras High Court is saying, that's point number one, why we are quashing this case in this case. Another thing that Madras High Court says is that in this case, the Tamil Nadu police, they had also used the provisions of POCSO Act of 2012. And again, the High Court says that this is not correct. This should not have been done. So Section 67B and POCSO case was implied over here. Now let me come to this one point. Everyone see here. In this article, they have written Section 67B has 5 sub-clauses from A to E. I do not expect you to remember all that. But in this case, the author is talking about, look at the clause number 2. That is the clause number B. Under Section 67B, it says, sub-clause B deals with acts including downloading of child pornography and material. So the author is saying that the Honorable Madras High Court has ignored the sub-clause 2 or Section 67 clause B, where clearly downloading a child pornography material is also a crime, whether you circulate it or not, whether you watch it in private or not. But then this also is a clearly, I would say, crime. And under this, if there is a first conviction, there can be imprisonment of any term, and later it can be extended to 5 years, and there might be a fine up to 10 lakh rupees. So the honorable, former IPS officer is saying that everybody agrees that in this case, there were 2 files of child porn that were downloaded, and they were recovered from the mobile of accused. In the case or in the judgment, even the forensic science report, they had made it very, very clear that yes, it has been found. So the author is saying, if you have already got two files, apply section 67 clause B, which clearly says if you have downloaded any of these child pornographic material, it should be, punishable. So here in this case, the author's point is that the Madras High Court has ignored 67B, that should not have been done. Now, even if, he is saying that if you are considering Kerala High Court's judgment, again the author disagrees that that should not have been used because that matter was related to pornography. Please understand, that matter was not related to child pornography. So the author is saying that matter was not concerning with child pornography but only with pornography. So even the Supreme Courts, High Courts, all of them have clearly said that sexually explicit material being watched in private, that's not an offense. But in this case, this was a case of child pornography, so this particular person should have been punished, and therefore the author is saying this judgment is unconstitutional. Now, third part in this judgment that the author is raising is that Madras High Court used its power under section 482 of CRPC, Criminal Procedure Code, to quash the judicial proceedings. Now, author's point is that Madras High Court is wrong in this regard also, in the sense that the author is saying that Supreme Court has put certain guidelines when it comes to state of Haryana versus Bhajan Lal. If you all remember, Bhajan Lal used to be a former Chief Minister of Haryana, and this judgment came in 1992. These guidelines are concerning CRPC section 482, that is how they can be used by a court, or if you see it, this is the extraordinary powers under Article 226. So the author also talks about this. So all these things are being talked about, and the author at the end has also talked about removal of the inconsistencies as how the words are used. That is, the wording is child sexual abuse material. The author is using or saying that this term CSAM should be preferred over the word pornography. Why? Because this term pornography implies that a consent was given, which in the case of child, he never ever gave the consent. He is not, or he or she is not capable of giving that. So the author is also saying, do not use these terms like child pornography. Rather, we should replace the word child pornography with the term CSAM. So that's another point that is being raised by the author here. With that, we are done with this. Coming to the last big topic of the day. In the polity, there is can treat scheduled caste as homogeneous group, observes the CJI-led bench. Now, Supreme Court is saying that the scheduled castes, they cannot be treated as homogeneous. Homogeneous means that has got no dissimilarity. When it comes to granting reservation, as one may have advanced in society, that is within the scheduled caste community, one caste may have advanced, another caste may not have advanced that much. So some might be particularly underprivileged. So remember here, a 7-member constitution bench is listening to this matter, and in that It is being led by Mr. D.Y. Chandrachud, the Honorable Supreme Court, our Chief Justice, and the bench has pointed out to this particular thing. As you all can see, Centre is saying that it is committed to reservation policy. Centre has made very, very clear. And in this case, you have Tamil Nadu government as another party which says that reservation policy should keep on evolving with the time, otherwise it will get fossilized. Now, see here. The matter is that it is the duty of individual states to identify and then subclassify backward classes within SC category so that they can give some much more power or much more reservation. Now, you all must have studied Article 341. You know, all the diverse groups are clubbed under the precedent list of this article of the Constitution, and they are termed as scheduled caste. Now, yesterday while this argument was going on, senior lawyer, senior advocate Mr. Kapil Sibal, he said that the scheduled castes who have faced a lot of humiliation in the past, have faced a lot of dehumanization, and they have already faced all this. And if you look at the groupings, names are Sapera. Sapera is in Hindi. In English, you all must know the snake charmer. Similarly, another word, Bazigar, you know, those who are acrobats. Similarly, Batwal, that's your watchman. So his point was that if you look at the nomenclature clearly, there is already, because of the various occupations that they practice, already there is a heterogeneity that is there which could be clearly seen. And even CJI yesterday agreed that we know and we can see clearly that there is heterogeneity when it comes to occupations that is practiced, social status that is there, or the social indicators. Now, in these indicators, the Chief Justice yesterday pointed out, look at the data related to infant mortality rate, look at the maternal mortality rate, look at the fertility rate, and all these numbers would clearly indicate to you whether a particular community has progressed or not. Last but not the least, remember, guys, this is stark opposite view to the judgment given in the last case, E.V. Chinnaiya case. This had come in 2004. In that case, exactly, if you all see, 20 years ago, a 5-membered bench, they had said that scheduled castes, they are homogeneous, and if we do a subclassification of this category, it would be violation of right to equality. Remember, this case, E.V. Chinnaiya case, was there versus the state of Andhra Pradesh. And a lot of people felt that this was against the common wisdom that there is heterogeneity when it comes to these community members, and they had raised concerns with regards to this. So again, this is an observation. Let us see what all comes out of this. The whole idea should be, the whole philosophy on which the reservation has been granted to a great number of our population is that it should aid the weakest of the weak. Those who really need it, they should definitely get it. And that's how there should be, the whole, judgments, or the whole, I would say, your talks on this issue done. Moving ahead, let us move to the Prelims Bytes. Now, this is a very, very big article on page 11, and I will tell you, remember 2-3 facts in this with regards to prelims. As you can see, neural network has got or has helped in finding of a new antibiotic. So look at this. History has a curious answer. The year is 1944. First time scientists have proposed first artificial neural network Neural network means a technology which later led to the birth of deep learning and AI systems like ChatGPT. Now, all of you keep on studying about AI. I don't have to get into that. But then, where did it all begin from? 1944. Same year, the biologists, they discovered streptomycin. Please remember this. This was world's first aminoglycoside antibiotic, and later it would revolutionize the diseases or the treatment of diseases like tuberculosis. Now, again using this, there is a paper published in 2023 December in Nature magazine, where scientists are claiming that they have discovered a new class of antibiotics, and clearly this has been done using a form of deep learning, and it's getting a lot of attention. So for me, for prelims, I want you to remember the facts which are written here, that another, I would say, antibiotic has been discovered, and thanks to the AI use, this has been discovered. So do remember this. In this article, if you will read, you will find very clearly that they have used these new products on mice, those which were infested with MSRA infections. Everyone, what is the full form of MSRA? Think about this before I tell you. What do you know? What do you know about MSRA? What exactly is the full form of this? Hopefully you would have written or you would have remembered by now. Methicillin resistant Staphylococcus aureus. Forget the full form. Remember at least MSRA. Was very much in news in 2019 when it contributed to the death of more than 1 lakh people. Human deaths had happened that year. So do remember it. Do remember this term. There is neural networks are made of neurons. These are artificial neurons which are used to make these neural networks. So 2-3 facts for prelims you should remember here. Moving ahead. Very small article for art and culture. Tripura board allows Kokborok in Roman script in the examination. So you can clearly remember, what is this? This is a language. Where is it written or where is it used? Second fact, Tripura. Third, this has got 2 scripts, Roman and Bangla. And right now they have allowed the Roman alphabet to write the exams. This is the language spoken by majority of the tribes in Tripura. Now, many academics, they feel that if you write Bangla script, it is much more practical, but those which are indigenous forums and the parties, they prefer that Roman script should be there in order to have a distinct identity. So please remember, this is a language earlier also known as Tripuri, and it is a part of Tibeto-Burman language which is spoken in the state of Tripura. Around 1979 it was discovered, or it was appointed or nominated as the official language of Tripura. So from there it comes. So do remember this being a language which is spoken by a majority of the people of Tripura. That's the thing. If anyone wants to know what is Kok and Borok, Kok means verbal, Borok means people. So do remember this. Now let me ask you another question, because I started this topic and the question was in my mind there only. Everyone, answer this. How many states in India has only one Indian state as their neighbor? The options are 0, 1, 2, 3. Those who are saying 0, no need to give any other answer. Those who are saying 1, tell me which is that one state. Those who are saying 2, tell me which is those 2 states. Those who are answering 3, tell me which are those 3 states. Question is, How many states in India has got only one other Indian state as their neighbor? That's your practice prelims question for the day. Moving to the last topic of the day, medieval history topic. A 390-year-old lamp post in Nalgonda has been discovered. If you see, this is the exact image of this lamp post. Why it is important? Now think about this, everyone. Number one, it's 390-year-old. So every one of you, you can understand it goes to medieval history. Found where? In a village of Nalgonda. Nalgonda is in Telangana. So from geography through map, remember this thing. There are very, very strange thing because lamp posts usually are rare in Deccan. According to the archaeologists who have discovered it, it is around June 1635, dated to that. Language written is Telugu mixed with Tamil language, dedicated to Kashi Vishwanath, and most probably would have been serving as a lighthouse for those who were using the riverine trade route. And in this article, they also have talked about diamond trader Tavernier. So if you see this article, as I said, it's 390-year-old, so concerned with medieval age. Found on the edge of river Krishna. So you can see, those who don't know about river Krishna, go and look into geography through map. Such an important river in South India. Nalgonda district. Where it is, again you should know, Telangana. Now, this pillar is around 20, I would say, foot pillar, and it has got hollows for lamps, and as I said, has got multilingual inscription. Now, why are the archaeologists surprised? Because they have never ever seen anything like this in this place. Lamp posts are very, very rare in this side, though they are very much prevalent on the western coast, including Goa, but they are not that prevalent on the eastern coast. As I have already said, it is multilingual inscription. Telugu and Tamil is found out or is seen over here. Now in this article, they also talk about two things. One, this village where it has been discovered is 180 kilometers from Hyderabad, and those times this area was ruled by Qutb Shahi rulers. So one thing you should know, study about Qutb Shahi in your medieval history, do know about them. Another they have mentioned is that Tavernier, who was a very, very famous diamond merchant who made 5 trips to Hyderabad kingdom in those days. He describes the land routes and describes the riverine trade. Now hopefully in the chapter of I would say foreign travelers, you must have known about this name, John Baptiste Tavernier. He was a French gem merchant, traveler from France, had traveled extensively in Iran and India in those days, and in those days he had come to the kingdom of Golconda. Also went to the court of Shah Jahan. So these facts you have to remember. Who is the ruler of France at this point of time? In Arrival of European chapter, you study Louis XIV. On his behest, he had even written a book. I'm forgetting the name. 6 Voyages. If you translate it, he had written this book, 6 Voyages, in which he had extensively written about diamonds and the Indian diamond mines, and was world over famous for discovering and purchasing the blue diamond, which he had gifted in those days to Louis XIV. So that was done by him. So you should remember these facts about him. As you can see, this is a purely prelims topic. Last I have given you 2 questions. The first is the attempt to end the fossil fuel uses should keep the concerns of developing nations in mind, critically analyze. India needs NGOs that are transparent. NGOs need to follow government regulations, but too much of the regulations are wrong. Comment 250 words. Think about this, write the answers, and if any one of you want to attend any of the counseling sessions, do fill the form and we would be more than happy to help you. With that, we are done with the session. See, I've got a lot of comments to cut down on the time which I'm giving on the CNA. I would suggest 1 hour, 1 hour, 10 minutes is something that you should always be prepared if you are doing the things in a holistic manner. Because the more you read the newspaper, the better you read the newspaper, the better your chances of clearing this exam. Do comment in the comment box. How did you like this particular session? How do you appreciate this particular session? Do like it, subscribe it, do share it, and let us again meet tomorrow in another session. That's all from today's class. Thank you. Goodbye.